the CS for Interior is completely in charge of the policy.
Yes.
And there is no government policy for anybody to be abducted. Number two, my lord, the policies that the police operator are found in police standing orders. They arrest, they don't kidnap.
Yes.
Once they have arrested, they detain those arrested in a gazetted cell holding ground. That is the policy.
Yes.
And to date, no record has been shown that anybody is in a police cell. Third, the constitutional policy guideline, Article 49F, demands that if the police arrests, they present the arrested person before a committee within 24 hours. That constitutional issue makes the order habeas corpus non-existent under the Constitution of Kenya. Philosophically and historically, the police could detain somebody for as long as they wish under the old Constitution.
Yes.
That was the reason habeas was alive. Today, the policy guideline is 24 hours. An extension, they'll come to explain to the court why there is that delay to produce somebody in court.
Yes.
So, my lord, based on the question you asked, why are courts going to the CPC? Why are the courts going to the statute to get explanations of habeas? The framers of the Constitution were very clear that the police then, as a police force, was operating without policy guidelines. The police service now operates under policy guidelines. And that is what Mr. Nyamodi and all the advocates representing the state apparatus are saying. Those people are not within police cells. But the last limb the Interior CS wants to raise is a question they have framed that there are omissions on their part. The police have done omissions in doing their jobs. Is this the right forum if the police fail to do what they are supposed to do?
Yes.
This is not the right forum. Habeas cannot be a remedy for a police officer who has failed to arrest. Habeas corpus cannot be the remedy that the Inspector General has either neglected to do a job. There are administrative procedures as policy provided for on dealing with police officers who might have disciplinary issues. My Lord, I urge this court to completely deny the invitation to deal with the questions of omissions. The only limb available is that, are these people in the hands of security apparatus? The answer is no. The remedy as policy is then investigations commence. Have the police started investigations on the whereabouts of the missing people? Yes. Are those investigations provided for in terms of timelines by policy? No. There's no policy guideline that says this investigation should take 2 weeks. So, my Lord, it is the fifth respondent's prayer that this matter is wrongly before you. Let the process of the missing person proceed, and let the police be allowed to do that which they have started, and they have not contravened any policy guidelines in terms of the way they have conducted their matter. Lastly, my Lord, you were told that these people missing were held by people who operate like the police. Several institutions in this country, and any big institution runs like the police. Guns are not a preserve of the police alone. There was no identification of anybody in a police marked police vehicle. Therefore, assertions that circumstantially the behavior of the people who committed the offense looked like the police don't operate in any of those manners. It is a disciplined force that follows strict adherence to the constitutional provisions of their mandate in Article 245 and 244.
Yes.
My Lord, we urge the court to make that finding, that the police have done extremely well to trace the petitioners, and as and when they'll be found, the police will deal with whoever has those people as criminals.
Yes.
And that is why the offense of abduction is available to others, but it is not available to police officers. They cannot abduct anybody, and they have not abducted any petitioner. May the court get favor in our submissions on behalf of the fifth respondent.